Could Young Thug get bail? Things are looking a little bit shaky out there. You got some evidence that has been suppressed. We finna get right into this audio because I definitely don't like to waste you guys' time. Y'all drop a like and drop a sub if you can.
15. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better.
And by the way, when the audio comes back, I'll go back over there. People are looking at the official, what's the official word on Gunna from like thugging them. And this is yesterday though, but the label's Twitter posted first day out with the slime emoji, tagged Gunna. And we see Gunna right here.
The item not executed within 10 days from the time of issuance shall be void. 17-5-25, the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal it. And say break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that case matters to this. That they had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question, and I thank. If I'll answer any other questions, but I hope I answered your question.
You did, sir.
I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time. And it's clear in the transcript that he did in fact assert the fruit of the poisonous tree.
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. And I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though, that's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and
The house was valid, and he hasn't done that, meaning the prosecutor has not done
only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is at page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper. And we have testimony. We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We will explain why all of that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and, Your Honor, there just wasn't. And, Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree. And if the court were to find...
I think you're going to get might have been a plea agreement that he may have reached to, which I would have said this whole case is just garbage, because if y'all let go of one of the co-founders, which was Walter Murphy, which obviously he's not famous, right? So nobody's caring what plea deal he signed. I got to imagine his plea deal also says he might have to testify too. I'm just saying, right? They're letting things some out of jail extra early, and some they're trying to pile on. So you got to realize they're setting sights on few people. Jeffrey Williams, aka Young Thug, is definitely one of them. They're definitely setting sights on. Anyway, the conversation that people are talking about, did Gunna snitch or not? I've been noticing everybody's hesitant to talk about it. And I think people are going to really allow Young Thug to basically come out and either say that dude is snitching on me or say he's not. And honestly, if Thug comes out and Thug doesn't say that Gunna snitched on him, I don't think people will call Gunna a snitch, honestly. You get what I mean? I think everybody's been guarded in their words. I seen Meek Mill yesterday tweet out, yo, welcome back, Gunna. You ain't deserve to be there. but then he deleted the tweet. And I think everybody's kind of in limbo, not trying to jump out the window because, again, at the end of the day, none of these guys in the industry.
And it goes on to say, when a final verdict and judgment is entered in finding a defendant guilty of the commission of a crime, any personal property used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case of property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different, different than 17-5-30, which is pre-trial. So this is this is trial evidence, or what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that, because you would have still had to return his property to him.
Your Honor, I'm sorry, I have to respectfully disagree with the court. Here, it's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, that's not otherwise illegal, is returned. The 17-5-30 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the.
Well, y'all heard it first. Do you think Young Thug could get bailed out? Y'all sound off in the comment section below. Thank you so much for tuning in. Keep it locked right here at 1 Minute Hip Hop, because we got a bunch more audio coming your way. Drop a like and drop a sub on your way out. I'll catch you guys on the next video. Easy, y'all.